Now, joining us is Brett Herron, who's the Secretary General of the Good Party. A very good evening to you, Brett. Instantly into it, you just heard what the Minister of Land had to say about this new bill being signed in from the Good Party. How do you feel about the signing?
Well, we welcome the implementation of the Act. It's long overdue. It provides much needed clarity on the future of expropriation, which has been the subject of a lot of debate. And it brings an appropriate balance between the duty of the state to give meaning to the constitutional provisions of redress, including land reform, and the protection of private property owners' rights. So the Act, we think, is a vast improvement of the 1975 Expropriation Act, which has been used for the last 5 decades, and will assist government to deliver, if it has the political will, on the land reform crisis in our country.
Speaking of the political will, government over the last 30 years has shown quite little political will when it comes to the issue of land. Are you confident that this time, with this particular signing of this bill into law, that this might change?
Look, I don't think there's a lot of room for excuses for the failure to implement land reform over 30 years. And government would be dishonest to be saying that, or to hide those failures behind any legislation. But the enactment or the implementation of the Expropriation Act, the new Expropriation Act, is another tool in government's arsenal to speed up the process of land reform. As the Minister of Land Reform was just talking about, the process has been takes far too long. So here we have a new piece of legislation that empowers government to do what it must to bring justice and equity to those who've been dispossessed of land historically, but also to address in urban areas the injustices of the apartheid spatial plan. So it's a tool that government must use if it has the will to do so.
There are those who are quite cynical about this as well. There are those who are the opposition parties, there are parties in the GNU as well, who are quite cynical about this for different reasons, of course. And I want us to just take a look at the Minister of Public Works, Dean Macpherson. He responded to this on social media, and I'll just read you the post that you responded to. We've got it up there on our screens, which said, as the Minister of Public Works and Infrastructure, there will be no expropriation of private property without compensation on my watch. The guarantee of property rights under Section 25 of the Constitution is not up for debate, and it is a non-negotiable. Well, you responded to that tweet, to that ex-post, and you said that he should probably resign because he took an oath to uphold the Constitution and he doesn't have the discretion to decide on the laws that he will implement and won't implement. So your stance is pretty clear there. This particular bill affects the Public Works Ministry. We have the Minister of Public Works saying it will not happen. How should South Africans react to that?
Well, South Africans should be dismayed by the Minister's post, or his comment, his statement. He is the custodian minister of this act. He took an oath to uphold the Constitution, to implement the Constitution and all other laws of the Republic. And he would be in breach of the Executive Ethics Act. He would be in breach of his oath of office. And he'll be in defiance of the government of the day's cabinet. So I think that it was a shocking display of personal preferences without fully even understanding what the Constitution says, to cite that he's going to protect the Constitution. He clearly hasn't read the judgment from 2002 that was delivered by the Constitutional Court, which said expressly that there are circumstances when it would be just and equitable for property to be expropriated without the payment of compensation. So this minister, who is charged with enacting and implementing this act, to say that that he's defending the Constitution by not implementing the act, is in breach of his oath of office, and doesn't understand the Constitution. I think he also has a conflict because if, as his party, the DA, have threatened, they challenge this legislation, this minister will be cited as the respondent in that litigation because he is the custodian minister of the Act. And if it is Cabinet's decision to oppose any litigation against this Act, in other words, to enforce the Act and defend the Act, it will be his duty as a minister to defend the constitutionality of this Act. And if he can't do so, if he's conflicted, then he must resign.
I want us to also look at a number of the contestation. You know, as you've mentioned as well, there have been legal threats and all. The other issue here is overpricing when it comes to land, when government then goes to landowners to try and get that land and pay for it. But then there are instances, many of which where the land is overpriced. Does this new law ensure that that doesn't happen anymore? And how so?
So the new law doesn't substantially change the previous law, which provided for market value to be paid for land when compensation is paid. So when we're talking about land that is overvalued, the state will pay market value. If the property owner disputes that, under the old law, the 1975 Act, the property owner would then have to take government to court and contest either the expropriation or the compensation amount or both. The only change really, and it's got nothing to do with the value of the land, is that under the new Act, if a property owner disputes the expropriation or the amount, including if the amount is nil or zero compensation, then the property owner can impose on the state the duty to go to court to prove that the expropriation is just and equitable and the amount is appropriate. So it doesn't really change the valuation process that is used for expropriation.
All right, Brett Herron, thank you so much for your time this evening. That's the Good Party Secretary General, Brett Herron.